I spent 3 decades in the Canton Police Department. I was a sergeant for 22 years.
Yes.
How can we stop the weaponization of the judicial system in Norfolk County so that he and the Canton 9 and me and anyone else here doesn't get a call from Mello and say, go do this? Please, how do we stop that? Does Levy have to come in and take Morrissey out in handcuffs? So how do we fix it?
I sure hope so.
And Kamala,
Good morning, Your Honor.
you have the motion?
I do, Your Honor.
You ready to argue?
Yes, Your Honor.
All right. Mr. Brady, I'll hear you whenever you're ready, sir.
Thank you very much, Your Honor. Your Honor, Mr. Schiffer comes before the court charged with the felony of witness intimidation, the misdemeanor of criminal harassment, and several counts of littering. The defense argues arguendo and doesn't assume any or admit any facts alleged, Judge. This is all assuming the facts in the light most favorable to the Commonwealth. So we don't, the way I argue it will not be an admission of any conduct on the part of Mr. Schiffer, if I may. Judge, this case starts out with a 36, 37-page criminal complaint that lays out laborious efforts on the part of the Canton Police Department to send subpoenas and find and execute search warrants and constantly visit Mr. Schiffer and look for statements and evidence. The problem for the Commonwealth, however, is that this 36, 37 pages is an investigation in search of a crime that never happened. There's no crime here, Your Honor. In terms of witness intimidation, Your Honor, there's no predicate act that can be looked at by the court in any possible way as a predicate act that would trigger the statute. There's no threat. There's never been any contact whatsoever between Mr. Schiffer and these complainants. There's no allegation. There hasn't been any actual face-to-face contact with these people. So if you have to go through the motions of it, the only possible predicate act can be a threat towards these complainants. There's no threat. A threat is not, it's not communicated to any specific person. There's no realistic, way that distributing a leaflet or a rubber duck can be perceived as a threat directed at a particular person. So the whole thing fails on the predicate act, Your Honor. It's absolutely absurd to assume that there's some sort of threat that arises out of this. The second factor here, Judge, in terms of Mr. Schiffer's expression, all of these acts are completely protected by the First Amendment. I'm not going to go through all the case law. I put it in my motion, case after case after case, protects much more egregious conduct, protects even facially apparent threats are protected in most contexts. So there's really no way that the government can proceed in terms of this felony charge. Same thing on the misdemeanor criminal harassment, Your Honor. Same thing here. As the courts, I'm sure well aware, I know you deal with this every day, O'Brien v. Borowski limits the grossly overbroad reach of the criminal harassment statute to only true threats and fighting words. And here, there's no true threats, certainly no true threats for the reasons I just got into, and there's certainly no fighting words. That's not even on the table. So O'Brien v. Borowski also limits the fear that's in the criminal harassment statute to fear of criminal consequences, bodily injury, damage to property. Not fear that I'm going to get sued, not fear that I'm going to lose accounts, not fear that I'm going to be upset by people's speech. So all these things, Judge, are completely insulated from criminal scrutiny by the First Amendment, which of course, again and again, I see in these cases is completely ignored by not only the Canton Police, the state police, Your Honor. They need a seminar on federal constitutional law. And, ignoring it is just not acceptable for a public agency to just go ahead and charge people and let the chips fall, cause them emotional distress, cause them money, cause them time out of their schedule, risk harming their reputation. It's outrageous. And we have a lot of faith. My client and I were talking about this court. We have a lot of faith and trust in this court, Your Honor, that you're going to see that for what it is and do the right thing in terms of allow the man to have his First Amendment rights. The last thing I want to say, Judge, is that Mr. Schiffer's charge is littering. There's a case right on point U.S. versus Schneider out of New Jersey, Your Honor. You're not allowed to selectively use littering laws to enforce a viewpoint. And that's exactly what's going on here. And there's absolutely no other enforcement of this law that's ever come into this court that I know of. If the court feels there should be some factual finding as to selective prosecution on littering, then I would ask that the court schedule a hearing and we can get some discovery from the Canton Police Department and see what exactly viewpoints do they use to employ the littering statute. And I guarantee you there's only going to be one viewpoint where they employ the littering statute, and it's anyone that's in favor of the Karen Reed camp versus the Canton Police, Mass State Police camp in the murder prosecution of Karen Reed. So it's selective prosecution, it's viewpoint discrimination. I gave you the case. This whole case, Judge, we respectfully ask, just wipe it clean. Throw it out of court, as they say. Thank you, Your Honor.
Thank you very much, Ms. Canton.
Thank you, Your Honor. Judge, Commonwealth is asking that you deny the defendant's motion to dismiss, as probable cause does exist within the four corners of the complaint application to support the accusations as charged. In terms of the criminal harassment statute, Judge, the instructions read, whoever willfully or maliciously engaging in a knowing pattern of conduct that seriously alarms or would cause a reasonable person to suffer substantial emotional distress. The report indicates, Judge, that was part of this complaint application, that the defendant has done just that. The application alleges that the defendant willfully, on at least 7 separate occasions, directly placed items, rubber ducks, fake $100 bills, within various locations throughout the town of Canton. These locations were specifically targeted by the defendant. 6 out of 7 of the times that these items were placed, that are outlined in the complaint, were at a specific location. 6 of those times were at D&E Pizza in Canton. D&E Pizza is a family business owned by Chris Albert, a business where his son Colin Albert frequently is present at, and the messages on these items referencing Colin did it are directly related to the owner's son, accusing him of the murder of a Boston police officer, John O'Keefe. Both Chris Albert and his son Colin are witnesses in that trial, were witnesses in the previous trial, are expected to be witnesses in the later trial. And again, Your Honor, this location was targeted nearly every time.
I didn't read the police report in the way you just characterized it in terms of at that specific location. I read it that it was Canton Center in the vicinity of that business and a number of other businesses. Am I incorrect there?
You're not incorrect, Judge. They were placed in various locations. However, 6 out of those 7 times they were in the direct vicinity. I believe the report read within 200 yards of that.
200 yards?
I believe so, of
That's
that
2
location.
football fields away from.
Yes, Your Honor.
Right, and I know I can't see 2 football fields away now with my own eyes, but okay, go ahead.
Sometimes I can't either, Your Honor.
Keep going.
Okay. Commonwealth would contend that this willful, targeted, and specific behavior would not only cause Chris and Colin Albert, but any reasonable person to suffer emotional distress. In terms of the intimidation of a witness charge, Judge, a portion of that intimidation charge holds that any person who willfully or directly threatens, attempts, or causes emotional injury or to harass another person who is a witness or potential witness in order to harm them for their participation in court proceedings. As stated previously, Judge, these spots are specifically targeted by the defendant. If you look at the jury instructions in regards to the intimidation statute, it reads, you can examine the defendant's actions and words and all the surrounding circumstances to help you determine what their intent was at the time. Commonwealth that would allege that it's not necessarily about a threat made to the victims, it's about what the defendant's actions were at that time. It does not require that the victim be placed in fear or apprehension or harm. The fact finder, being judge or jury, can evaluate the circumstances of what the defendant intended at the time of what he was doing. These specific locations included the businesses and residences of the places of employment for witnesses during that trial. And separate and apart from the criminal harassment and witness intimidation, Judge, the littering charge, these items were thrown and littered not only at the businesses in the town of Canton, but at residences of witnesses that are taking part in that Commonwealth versus Karen Reed trial. The police report goes on to explain that specifically at one point, the defendant is alleged to have placed these rubber duckies on the property of John O'Keefe's residence, where his elderly parents reside, along with his niece and nephew, who again were witnesses in that prior trial. The police report alleges the defendant admitted that he littered and spread this propaganda on several occasions. At one point during a live stream, he stated while holding up one of those ducks that said Colin did it, that this is a trigger word. It's you know, it's not the items. It doesn't matter that it's a rubber duck or a fake $100 bill. It's just the pattern of harassment, of witness intimidation. It's systematic. It's not an issue of freedom of speech, Your Honor, when you have a campaign of criminal harassment that specifically targets a select group of people for purposes of harassment in a murder case. There's no threat. It's just simply harassment. The Commonwealth is asking that you deny this motion to dismiss. It's evident, Your Honor, that within the four corners of this complaint, there's more than sufficient probable cause to support each and every one of these accusations, and I ask you to allow the case to proceed to a fact finder. Thank you.
Radel, did you have anything in response?
Just a brief response relative to the location issue. I don't think the government really can make an issue of the location of the protest. I mean, it doesn't make sense to protest something, you know, 3 towns away from where the target of your protest is, and to leave things around in the general vicinity of downtown Canton, you know, has to be protected under the First Amendment. That's where the parties are. That's where the town center is, and you know, that's perfectly acceptable. You know, it's literally cliche of protesting in the town square. That's where you're allowed to protest. So in terms of the location of it, shouldn't be used against anybody. Thank you.
All right, thank you.
Thank you.
All right, I do agree with the defendant that the application for the criminal complaint and related materials lacks sufficient probable cause to support both the criminal harassment and witness intimidation charges against the defendant. The defendant's conduct, in this court's opinion, did not rise to the level to support either of those charges, nor does his speech, which are afforded the protections of the First Amendment and Article 16 of the Massachusetts Declaration of Rights. Therefore, I'm allowing the defendant's motion to dismiss counts 1 through 4 only. At this time, the other counts will remain viable.
Thank you, Your Honor.
All right, where's that? Okay, they'll be out later, right? All right.
What a win. What a win. What a win.
Really?
Oh, yeah, Tom, that's a huge win. We got to get Rich Tripp on his way up. That's a they dropped felony witness intimidation charges and the criminal harassment charges. He's still being charged with littering, though.
Okay.
Okay.
Awesome. That's the deal, all right? Is that bad? Bad dude?
It is a gigantic win that they just dismissed these charges outright. He said there's no probable cause, which makes you wonder, how did it get past the probable cause phase in the first place?
Right.
In front of a judge. No clerk magistrate looked at this. They just charged them. Officer Lehan's sitting there taking the L. You know, I go, tough loss. You got to swallow that one, pal. You guys wasted how many hours on this crap? And it got dismissed. Witness intimidation, dismissed. They laughed at the Canton Police Department. How many of these more bogus complaints need to be brought in front of judges and dismissed outright? So, great day. I mean, the Bukkake bunch were never charged. The Canton 9 were never charged. This never should have been brought. That's what the judge just said in there, that there's no probable cause for any of this crap. How embarrassing that sham ADA hack got up there and had to say the word rubber duckies 3 times with the straight face. How she didn't start cracking up is beyond me. I mean, do you like your job? Are you not embarrassed? Are you not? Do you like your job that much? Is your cheese sandwich that delicious that you go home to, that you had to come into work and then you go home at night and say, what'd you do today at work, honey? Oh, I had to try to prosecute a guy for rubber duckies and it failed. The judge just dismissed it. But we're going to get him for the littering.
So I'm back for littering.
You're back for littering.
What a bad dude.
Take him into custody, serial litterer right here.
Yeah, 17.
17? How big of a win is this, Tim?
Well,
I
this is
got
the
it.
first time, guys.
Come down, come down.
This is the first time, guys, we've gotten a judge to really speak and defend the First
Hang it
Amendment.
up. They called
You
my
know,
cell phone.
He couldn't wait.
Hang it up. They called
Shelby.
my cell phone.
Shelby, shut up, Shelby, please. All right,
Guys,
sorry, Rich.
This is really important. This is the first time we've had a judge. This is our 6th case of this. 6 times. We're 5-0, but nobody wants to just stand up and say, what is going on here? This is a violation of the First Amendment. Hats off to Judge Walsh for really finally standing up. And I just love the fact that he was ready to do this on the spot. How many times, even when we get the right result, how many times do they go hide in their office for 3 weeks and then they just say, oh, dismissed, yeah, we'll get rid of it. But
Same judge who denied Jen McCabe's restraining order.
that's right.
Same judge.
Right. He's a defender of the First Amendment. Hats off to Judge Walsh for doing the right thing, for standing up. And, justice delayed is justice denied. And he gave us justice on the spot. So I really appreciate that. And, that's what we need. More judges like that to just wipe this stuff away. Let us speak. Let us speak out. Let you guys, do your thing. Let you speak up to the government. Let you tell them what you think of how wrong and how awful everything they're doing is. And let's look at this as a first step. And we're going to get a hold of Judge Walsh's decision. I'd love to see it on a couple of signs, put it on a billboard somewhere, along with Rich's face.
That's been done.
Attorney Brado,
Yes, sir.
question. So the judge said that it's dismissed for lack of probable cause, which begs the question, how did it get past the clerk magistrate? Aren't they the ones who decide on whether or not probable cause exists?
Well, oftentimes you'll have a clerk magistrate who look at the complaint. There's often a reluctance to kind of weigh in any sort of comprehensive way. That's what these cases will often get to the judicial level where you do have time to write a brief, to argue, and to.
So did this case go to a court?
It did. And so what happens here is that.
But there was no hearing for it.
Correct. It's not an adversary hearing. There's no cross-examination like a clerk's hearing. When there's a felony charge, which this ridiculous witness intimidation charge was a felony. So Rich was looking at a felony. We can joke around all we want, but that is a goddamn serious thing to have to be under a felony charge for speaking out, spreading rubber ducks around, and you're under a felony charge. It's lawfare. That's a great way to put it. It's lawfare to cause emotional distress to people, to cost them money, to get in their way, to hurt their reputation with people who don't really know what's going on. So it's very upsetting. It's wrong. And Judge Walsh, again, hats off to Judge Walsh for calling it like he sees it, like how any reasonable judge with any degree of fortitude should see these kind of cases, which is that they're complete jokes. It's tyrannical, it's authoritarian, and it does not belong anywhere near a courthouse in America.
Are all the remaining charges only littering, or are there any charges other than littering that remain?
Just littering. Eight charges, I think, of littering.
Have you ever defended a littering charge?
I'm gonna have to go back to my files to find a littering case I've done. But this one is actually, like so much in this area where we're always grappling with these cops and these DA's offices. This is going to be a special case. I'm going to send a discovery motion. We're going to get the Canton Police Department's files on littering prosecutions they've done over the last 2-3 years, let's say. And let's see how many littering prosecutions. Let's see how many littering prosecutions.
Is that a hearing scheduled for January, or what is it exactly?
The 17th is just it's a pretrial date. So that's a date where the parties confer on what to do with the case. I'm going to file a motion for discovery on that day, seeking all the Canton Police Department's littering prosecutions over the last 3 years, so we can get a sense of context where how many times has someone who has protested and handed a leaflet out that gets crumbled up and thrown on the ground, how many of those people got prosecuted for littering? And we'll see. Absolutely, it's intimidation. How ironic that they intimidate us by filing witness intimidation charges. It's wrong. It's got to stop. And we are going to be, there's so many good, brave litigants that I have in this state, and we are going to be at the tip of the spear. We're going to blow up the statute. It's going to go south. I probably shouldn't say blow up. Maybe they'll arrest you. We're going to blow up this statute. We're going to get to the Supreme Judicial Court, and we expect them fully have every confidence that they're going to do the right thing. They're going to limit this statute. They're going to throw it out, because I know everybody here has experienced a chilling effect. Everybody here, as brave as you guys are, everybody here has had to think twice, right? You got to think twice whether you really want to say what you're going to say, because you're like, are they going to come after me? How many times have you guys gotten a doorbell ringing, a knock on the door, and it's the UPS man, but you think, oh my God, is that the state police? Are they coming for me? Right? That's wrong. That's wrong. And we're going to get this Commonwealth back to a state where everyone can speak out with total confidence, total lack of fear, and you can call out the government anytime you want. What do you say, Rick?
I say, I don't know what to say. All I can say is thank you for all your support. We're gonna beat this thing. I'm in it to win it. That's it. It is lawfare. We know what's going on. I know from the get-go. I knew I didn't do anything wrong.
Things are swinging back
It's
our way,
just-
and they're going to keep swinging our way.
We love you, Richie.
Thank you all, everyone.
That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
Judge's gavel slams to seat. Lawyers dance, twist up their seat. Finger points truth in the air. Crime scene chalk, we got there. Witness falls under the glare. Truth lies hidden, but where? Evidence in shadow cracks. Guilty walks with ducks and packs. If it walks like a duck and talks like a duck, it's a duck. If it quacks with a smack and waddles in the track, it's stuck. It circles round the facts, can't hide from the luck. If it walks like a duck and talks like a duck, it's a duck. Twist the tail, they change their tune. Photos snapped under the moon. Bloody prints and muddy paths. Money trails that never last. Defendants face behind a mask. Justice chained up to the past. Solitary cell they spin. Real truth trapped deep within. If it walks like a duck and talks like a duck, it's a duck. If it quacks with a smack and waddles in the track, it's stuck. It circles round the facts, can't hide from the luck. If it walks like a duck and talks like a duck, it's a duck.